I was halfway through my morning coffee when I heard the crunch of tires on gravel and looked up to see a pristine white Mercedes SUV pulling up to my cabin, which immediately told me this was going to be trouble. The woman who stepped out wore a pantsuit that probably cost more than my monthly utilities and carried a leather folder like it was a holy artifact. Her blonde hair was cut in that severe bob that screamed, "I demand to speak to your manager," and her heels were completely impractical for the rocky mountain terrain surrounding my property in the San Juan National Forest near Pagosa Springs, Colorado. "Are you Robert Garrison?" She called out, not even bothering with a greeting. I set my coffee down on the porch railing and stood up. "That's me. And you are Brenda Patterson, president of the Cascade Ridge Homeowners Association." She climbed the 3 steps to my porch without being invited. "We need to discuss some serious violations you're in breach of." I crossed my arms. "I'm not part of any HOA." "Actually," she said, opening her folder with a flourish that suggested she'd been practicing this moment, "your property falls within the boundaries of Cascade Ridge, which means you are subject to our covenants, conditions, and restrictions. And frankly, Mr. Garrison, this structure is an eyesore that violates about 17 different regulations." I looked back at my cabin. Sure, it wasn't fancy. The logs were weathered gray. The roof was simple corrugated metal, and the whole thing had that rustic look that came from actually being old rather than being designed to look old. But it had been in my family since 1952, passed down from my grandfather to my father and then to me 3 years ago when Dad died. "This cabin has been here since 1952, I said slowly. "What HOA?" "Cascade Ridge was established in 1989, Brenda said with the patience of someone explaining basic math to a child. "All properties within our boundaries are required to maintain certain aesthetic standards. Your cabin needs to be repainted or restained in approved colors, that metal roof needs to be replaced with architectural shingles, and you're missing decorative shutters. Also, your vehicles need to be parked in an enclosed garage, not just left in the driveway." "I don't have a driveway." "I have a dirt clearing where I park my truck." "Exactly my point." She pulled out a sheet of paper. "You have 30 days to come into compliance or face daily fines of $200. I took the paper but didn't look at it. "You do realize I'm not actually in your HOA, right? This property was here decades before your little neighborhood existed. The boundaries were drawn based on the county parcels," Brenda said. "Your parcel is included. I have the maps right here." She tried to show me another document, but I waved it away. "Let me be very clear," I said. "My grandfather bought this land and built this cabin in 1952. I have the original deed. Whatever HOA you think you're running doesn't have any authority over property that predates it by almost 40 years. Her expression hardened. "That's not how it works. When the HOA was established, all properties within the boundaries became subject to the rules. It doesn't matter when you bought it. Actually, it matters a lot." I'd had enough. "You need to leave my property now. 30 days, Mr. Garrison. After that, the fines start accumulating. And if you don't pay, we can place a lien on your property." She turned on her heel and marched back to her Mercedes, somehow not breaking an ankle on the uneven ground. I watched her drive away, then looked down at the violation notice she'd handed me. It was printed on expensive paper with a fancy letterhead, and listed all the supposed violations in bullet points with reference numbers to specific HOA rules. At the bottom was a statement about enforcement rights and legal remedies available to the association. I pulled out my phone and called my friend Marcus, who was a real estate attorney in Durango. "Rob, hey, what's up?" he answered. I just had the HOA president show up at my place claiming I'm in violation of their rules. What HOA? You're not in an HOA. That's what I said. But she insists my property is within their boundaries. Hold on, I heard typing. What's the name of the association? Cascade Ridge. More typing. Okay, yeah, that's the development that went in about a mile east of you in the late 80s. Bunch of vacation homes and retired folks. But Rob, your property isn't part of that. She seems to think it is. Did she show you a map? Tried to. I didn't really look at it. Look, don't ignore this completely. Sometimes HOAs try to expand their territory or there could be a legitimate boundary dispute. Do you have your deed handy? It's in the fireproof safe. Want me to bring it by your office? Yeah, come by Monday. Bring any documentation you have about the property. Original deeds, survey maps, tax records, whatever you've got. We'll sort this out. I spent the weekend fuming about it. The cabin was my sanctuary. After my divorce 2 years ago, I'd moved up here full-time. I did freelance graphic design work remotely, which meant I could live anywhere with decent internet. The cabin had been updated over the years with proper plumbing, electricity, and yes, internet, but it still maintained its character. That was the whole point. The nearest neighbor was half a mile away. I had acres of forest, a creek running through the property, and enough peace and quiet to actually think. The idea that some HOA thought they could tell me what color to paint my cabin, or that I needed decorative shutters made my blood boil. Monday morning, I drove into Durango with a folder full of documents. Marcus's office was in a converted Victorian house near downtown, which I'd always thought was fitting for a real estate attorney. His assistant showed me into his office, where Marcus was already pulling up something on his computer. He was in his early 40s like me, but he'd gone prematurely gray in law school and leaned into it with expensive suits and glasses that made him look distinguished. "Let me see what you brought," he said. I spread everything out on his desk. The original deed from 1952, signed by my grandfather, Richard Garrison Sr., and the previous landowner. A survey map from that same year showing the property boundaries. Tax records going back decades. A few photos of the cabin from different eras. Marcus examined the deed first, holding it up to the light like he was checking for watermarks. "This is the original. Good. And you have a clear chain of title from your grandfather to your father to you." "Yeah, Dad had it transferred to me in his will. I've got all that paperwork too." "Okay." He turned to his computer and pulled up what looked like a property map. "This is the current county assessor's map. Here's your property." He pointed to a parcel outlined in blue. "And this is the Cascade Ridge HOA boundary according to their filed charter." I leaned in to look. The HOA boundary was a large, irregular shape that covered what looked like a couple hundred acres of developed land. And right there on the eastern edge, overlapping with my property by about 20 feet, was a small section of my parcel. They're claiming that overlap gives them jurisdiction. I asked, "Looks like it. But here's the thing." Marcus pulled up another document. The Cascade Ridge HOA was established in October 1989. Their charter was filed with the county, and it includes a specific legal description of the boundaries. Let me read you the relevant part. "All properties within the boundaries as described herein, including any properties subsequently developed or transferred, shall be subject to these covenants." "Subsequently developed or transferred," I said. "But my property wasn't transferred after 1989. It was transferred from my grandfather to my dad in 1978 and from my dad to me 3 years ago. But the property itself predates the HOA." "Right. And that's the key issue. The question is whether the HOA can claim jurisdiction over a property that existed before the HOA did, especially when that property wasn't voluntarily enrolled in the HOA. Can they? Marcus leaned back in his chair. Generally, no. An HOA's authority comes from people voluntarily agreeing to be bound by the rules, usually when they purchase property in a development. You can't retroactively impose HOA rules on existing properties unless the property owners agree to it. But the wrinkle here is this boundary overlap. What about it? If their survey when they established the HOA was wrong, and they accidentally included part of your property in their legal description, they might argue that creates jurisdiction. But honestly, Rob, even if there's a technical overlap, you've got a strong case that they have no authority over you. Your deed is from 1952. It predates their charter by 37 years. So what do I do? First, I'm going to send them a letter explaining that your property predates their HOA and you are not subject to their rules. I'll cite the relevant case law and make it clear that any attempt to fine you or place a lien on your property will be met with legal action. Will that be enough? Marcus smiled. Probably not. In my experience, HOA boards that are aggressive enough to do this in the first place usually don't back down after one letter. They'll probably double down, but it establishes your position and creates a paper trail. Great, so I'm looking at a legal fight. Maybe. But you're in a strong position. The worst-case scenario is this goes to court and you win. They pay your legal fees and everyone moves on. Best case, they back off after the letter. What's the medium case? They try to push forward with fines and liens. You sue them. It settles before trial, and again, you probably get your fees covered. Either way, you're not going to lose your property over this. That made me feel a little better. Marcus drafted the letter while I waited, printed it on his firm's letterhead, and showed it to me before putting it in an envelope. It was 3 pages of dense legal language, but the core message was clear. Robert Garrison's property predated the Cascade Ridge HOA. He had never agreed to be bound by their rules, and any attempt to enforce HOA regulations against him would be vigorously contested. I'll send this certified mail today, Marcus said. They'll have it by Wednesday. Let me know if they respond. They responded all right. Not with a letter, but with Brenda Patterson showing up at my cabin again on Thursday morning, this time with 2 other people. One was a man in his 60s with a red face and a polo shirt that strained across his belly. The other was a younger woman with dark hair pulled back in a tight ponytail, carrying a camera. "Mr. Garrison," Brenda called out as I opened the door, "we need to discuss your attorney's letter." "There's nothing to discuss. My position is clear." "Your position is based on a misunderstanding of property law," the red-faced man said. "I'm Donald Kemper, treasurer of the Cascade Ridge Board. We've consulted with our attorney and you are absolutely within our boundaries and subject to our rules. Your HOA was established in 1989. This cabin was built in 1952. "That's irrelevant," Brenda said. "The boundaries are the boundaries. It's extremely relevant. I never agreed to be part of your HOA." "You don't have to agree," Donald said. "The boundaries determine membership, not individual consent." The younger woman with the camera had been walking around my property, taking photos of the cabin from different angles. "Excuse me," I called out to her. "What are you doing?" "Documenting violations," she said without looking at me. "Get off my property, all of you." "We have a right to inspect properties within the HOA boundaries," Brenda said. "No, you don't, not my property. Leave now or I'm calling the sheriff." "There's no need for threats, Mr. Garrison," Donald said. "We're just trying to maintain property values for everyone in the community." "I'm not in your community, and you need to leave." Brenda's expression turned icy. "You have 16 days left before the fines start." I suggest you use that time wisely." She gestured to the other two, and they headed back to the cars they'd arrived in. Two more expensive SUVs that looked ridiculous parked in front of my weathered cabin. I called Marcus as soon as they left. They just showed up at my place again. 3 of them this time, including one taking pictures. "Did you tell them to leave?" "Multiple times. Eventually they did." "Good. Don't let them on your property again. If they show up, tell them they're trespassing and you'll call law enforcement if they don't leave immediately. Then actually call if they refuse. You think it'll come to that? I think this board is used to pushing people around and not being told no. Document everything. Keep a record of every interaction, every letter, every phone call. If this goes to court, that timeline will be important." The next violation notice arrived in the mail 2 days later. This one included photos of my cabin taken from the road, with annotations pointing out all the supposed problems. Apparently, I also needed to install landscape lighting, replace my gravel area with poured concrete, and remove a non-conforming storage structure, which was actually a woodshed my grandfather had built in the 60s. The notice ended with a reminder that I had 12 days to comply. I scanned everything and emailed it to Marcus, who called me an hour later. "Okay, they're escalating. I'm going to file for a declaratory judgment." "What's that?" "We're asking a court to officially declare that your property is not subject to the HOA's jurisdiction. It's a preemptive move. We go on offense instead of waiting for them to file a lien and then responding." "How long will that take?" "Depends on the court's schedule. Could be a few months to get a hearing, but once we file, it sends a clear message that you're serious. Do it." Marcus filed the lawsuit the following week. I know because Brenda showed up at my cabin the day after she was served with the complaint, absolutely furious. "You're suing the HOA," she screeched from her car, "not even getting out this time." "I'm asking a court to confirm what I already know. That your HOA has no authority over my property. This is going to cost you thousands in legal fees. I'm fine with that. I'm not going to let you bully me into changing a cabin that's been in my family for 70 years. You're being completely unreasonable. All we're asking is that you maintain basic standards. You're asking me to subject myself to rules I never agreed to, about property that predates your entire organization. That's not reasonable, Brenda. That's an overreach." She sat there glaring at me through her windshield for a long moment, then threw her car in reverse and spun out, spitting gravel. The next few weeks were quiet. The 30-day deadline came and went without any fines being assessed, probably because the HOA's attorney had advised them not to take enforcement action while the lawsuit was pending. Marcus kept me updated on the legal proceedings. The HOA filed a response claiming that the boundary description in their charter clearly included my property, and that I was therefore subject to their rules regardless of when the property was developed. They also filed a counterclaim asking the court to force me to comply with the HOA regulations. "They're really doubling down," Marcus said during one of our phone calls. "Most HOAs would back off at this point, especially with your deed history, but they seem determined. What's their end game? Even if they win, which you say they won't, what do they actually get out of this? Control. That's what HOAs are really about. The property values argument is usually a cover for the fact that certain people just like having power over their neighbors." The preliminary hearing was scheduled for late September. I had to take a day to drive down to the county courthouse in Pagosa Springs. Marcus met me there in a suit that probably cost more than my truck. The hearing was in a small courtroom with wood paneling and a ceiling fan that creaked as it rotated. The judge was a woman in her 50s named Patricia Hendricks, who had a reputation for not tolerating nonsense. The HOA was represented by their attorney, a slick-looking guy named Bradford Hughes who wore cufflinks and had his hair gelled back. He stood up first to present their argument. "Your Honor, this is a simple boundary dispute. The Cascade Ridge HOA has clearly defined boundaries that were surveyed and filed with the county in 1989. The defendant's property falls within those boundaries. The age of his structure is irrelevant to the question of jurisdiction." Judge Hendricks looked at him over her reading glasses. "The plaintiff's property predates your client's HOA by nearly 40 years. How do you claim jurisdiction over property that existed before the HOA did?" "The HOA boundaries were drawn to encompass a specific geographic area, Your Honor. When those boundaries were established, all properties within that area became subject to the HOA rules. It's no different than being within a municipality's borders. Except municipalities are government entities with statutory authority. HOAs are private organizations that derive their power from voluntary contractual agreements. The contractor agreement exists in the recorded charter, Your Honor. By owning property within the boundaries, the plaintiff is bound by that charter." Marcus stood up. "Your Honor, may I respond?" "Please do." The HOA's argument fails on multiple levels. First, my client never signed any agreement to be bound by HOA rules. His property was not part of the original development. It's not a subdivision lot. It's a stand-alone parcel that has existed independently since 1952. Second, the deed to this property predates the HOA charter by 37 years. You cannot retroactively impose HOA rules on existing properties without the owner's consent. Third, even if there's a technical boundary overlap due to surveying error, that doesn't create jurisdiction. The HOA's authority extends only to properties that are actually part of the association, which requires some form of voluntary enrollment or agreement. Judge Hendricks nodded slowly. "Mr. Hughes, does your client have any documentation showing that Mr. Garrison or his predecessors in interest ever agreed to be part of the HOA?" "No, Your Honor, but that's not required under the charter language. The charter states that all properties within the boundaries are subject to the rules. But the charter is itself a contract. You can't bind people to contracts they never agreed to. That's basic contract law. Your Honor, this is well established in HOA law. When someone buys property in an HOA, they're bound by the rules even if they don't personally sign the charter. But they're buying property that's already part of the HOA, Judge Hendricks said. They have notice of the HOA and its rules before they purchase. That's very different from claiming jurisdiction over property that predates the HOA entirely. Bradford Hughes looked uncomfortable. Your Honor, if we allow property owners to simply opt out of HOAs based on when their property was developed, it undermines the entire system. I'm not concerned with the entire system, Mr. Hughes. I'm concerned with whether your client has legal authority over this specific property, and from what I've seen so far, I'm skeptical. She looked at Marcus. Do you have the original deed with you? Yes, Your Honor. Marcus pulled out the document, now protected in a plastic sleeve, and handed it to the bailiff who brought it to the judge. Judge Hendricks examined it carefully. 1952. And this is the actual original. Yes, Your Honor. Recorded with the county on August 14, 1952. She looked at the HOA's attorney. Mr. Hughes, I'm prepared to rule from the bench on this if you don't have anything else to present. Your Honor, we believe the boundary issue is dispositive. We have survey maps showing. I don't care about your survey maps. The question isn't whether there's a boundary overlap. The question is whether you have authority over property that predates your client's existence and was never voluntarily enrolled in your association. And based on the evidence presented, I don't see how you could. But I'll give you 2 weeks to file a brief addressing the specific legal question of how an HOA can claim jurisdiction over pre-existing property without the owner's consent. Mr. Marcus, you'll have 2 weeks after that to respond. We'll reconvene in 6 weeks for a final hearing. We left the courthouse and Marcus was grinning. That went well. She seemed skeptical of their argument, very skeptical. Honestly, I think she's already decided, but she's giving them a chance to make their case in writing. It's good practice legally, makes the ruling harder to appeal. So you think I'm going to win? I think you're going to win decisively. I felt lighter driving back to the cabin than I had in weeks. Maybe this whole thing would be over soon and the HOA would leave me alone. That optimism lasted exactly 5 days, until I came home from a grocery run and found an orange sticker plastered across my front door. Notice of violation, it screamed in large black letters. Below that was a list of the same supposed violations, along with a statement that the property was now accruing daily fines of $200, and a lien would be placed on the property if the fines weren't paid. I called Marcus immediately. They put a violation sticker on my door. And they're claiming I'm accruing fines. While the lawsuit is pending, that's bold and stupid. Take photos of the sticker, then remove it. Keep it as evidence. Can they actually do this? They can try. But if they follow through and actually file a lien, that's going to look very bad in front of Judge Hendricks. They're essentially ignoring the court process and taking matters into their own hands. I photographed the sticker from multiple angles, peeled it off carefully, and stored it in my growing folder of HOA documents. 2 weeks later, I got a letter from a collections agency claiming I owed the Cascade Ridge HOA $4,000 in fines and demanding immediate payment. $4,000, I said to Marcus when I called him. How do they figure that? $200 a day for 20 days, I assume. When did they claim the fine started? I checked the letter. October 2nd. Okay, so they started assessing fines right after the hearing, even though Judge Hendricks hasn't ruled yet. That's unwise. Forward me the letter from the collections agency. What do I do about them? Nothing. Don't pay, don't acknowledge the debt. I'll handle it. Marcus sent a letter to the collections agency explaining that the alleged debt was in dispute and subject to pending litigation, and that any further collection attempts would be considered harassment. He also filed a motion with the court asking for an injunction to prevent the HOA from assessing fines or taking any enforcement action until the case was resolved. The hearing on the injunction was scheduled for early November. This time when I showed up at the courthouse, there were more people in the gallery. Apparently word had gotten around about the case, and several other property owners had shown up to watch, including a couple who introduced themselves as having a similar boundary dispute with a different HOA. Judge Hendricks looked distinctly annoyed when she read the HOA's response to the injunction motion. Mr. Hughes, why is your client assessing fines while this case is pending? Your Honor, the HOA has an obligation to enforce its rules consistently. Making an exception for Mr. Garrison would be unfair to other property owners who are required to comply. Except that the entire point of this lawsuit is to determine whether Mr. Garrison is actually subject to those rules in the first place. By assessing fines before I've ruled, your client is assuming the outcome of this case. Your Honor, we believe our position is strong and I don't care what you believe. You should have waited for my ruling. I'm granting the injunction. The Cascade Ridge HOA is prohibited from assessing any fines against Mr. Garrison or taking any enforcement action against his property until this case is resolved. All fines assessed to date are void. Is that clear? Yes, Your Honor. Good. Now, I've read your brief on the jurisdictional question, and frankly, I'm not persuaded. You've cited several cases, but they all involve properties that were developed as part of HOA subdivisions. You haven't cited a single case where an HOA successfully claimed jurisdiction over pre-existing property without the owner's consent. Your Honor, we believe this is a case of first impression in Colorado. Then you're asking me to expand HOA authority in a way that no Colorado court has done before. That's a big ask, Mr. Hughes. Marcus stood up. Your Honor, if I may, there's actually a Colorado Court of Appeals case that's directly on point. Silverton Mountain Properties versus Alpine Meadows HOA, decided in 2018. The facts are very similar. The court held that an HOA cannot claim jurisdiction over property that predates the HOA's charter without clear evidence that the property owner agreed to be bound by the HOA rules. Judge Hendricks turned to her computer and started typing. I'm not familiar with that case. What's the citation? Marcus rattled off the case number and date. Judge Hendricks read for several minutes while the courtroom sat in silence. Then she looked up at Bradford Hughes. Have you read this case, Mr. Hughes? I have, Your Honor, but we believe it's distinguishable. How? The property in that case was several miles outside the HOA boundaries. Here, there's a direct overlap. The overlap is 20 feet according to your own survey. And it's disputed whether that overlap is even real or the result of surveying error. But more importantly, the court in Silverton didn't base its ruling on the distance. It based it on the fundamental principle that HOA authority requires consent. Do you disagree with that principle? No, Your Honor, but we believe consent can be implied by what? Mr. Garrison never bought property in your HOA. He inherited property that his grandfather owned decades before your HOA existed. Where's the implied consent? Bradford Hughes looked like he wanted to be anywhere else. Your Honor, if you rule against us, it will set a precedent that undermines HOA authority throughout the state. Good, Judge Hendricks said flatly. HOAs have too much power as it is. I'm ruling in favor of Mr. Garrison. The Cascade Ridge HOA has no jurisdiction over his property. All fines are void. The HOA is prohibited from taking any enforcement action against his property, and Mr. Garrison is entitled to attorney's fees and costs. Mr. Marcus, submit a fee petition within 30 days. I felt like cheering. Marcus just nodded professionally, but I could see the satisfaction in his eyes. Bradford Hughes made one last attempt. Your Honor, we would request a stay of your ruling pending appeal. Denied. This case is over, Mr. Hughes. I suggest your client accept that and move on. We walked out of the courthouse into crisp November air. Marcus shook my hand. Congratulations, you won, we won. Thank you for handling this. My pleasure. Honestly, it's satisfying to win a case this clearly righteous. A lot of property law is shades of gray. This was black and white. What happens now? I'll submit my fee petition. The HOA will probably try to lowball it, but eventually they'll pay. You're done with them. I drove home feeling better than I had in months. The cabin looked the same as always, weathered and rustic and perfect. I sat on the porch with a beer and watched the sun set behind the mountains, finally able to just enjoy my property without worrying about HOA nonsense. That peace lasted exactly 3 weeks. I was inside working on a design project when I heard vehicles outside. Multiple vehicles. I looked out the window and saw 2 pickup trucks and an SUV parked in my clearing. 6 people were standing around, including Brenda Patterson. I grabbed my phone and headed outside. What are you doing here? Community inspection, Brenda said. We're documenting the impact your property has on the surrounding area. The judge ruled you have no authority over my property. You need to leave. We're not on your property, one of the men said. He was younger than the others, maybe early 30s, with that aggressive confidence of someone who's never been punched in the face. We're on HOA common property. I looked at where they were standing. It was technically on the edge of my clearing, right where my property line should be. Even if that's true, which I doubt, you're harassing me. The judge's ruling was clear. The judge's ruling doesn't prevent us from conducting legitimate HOA business, Brenda said. What business? You don't have jurisdiction over me. We have jurisdiction over HOA property, and we're assessing whether your property is causing damage to HOA property. I called Marcus on speakerphone right there. Marcus, the HOA is here again. They claim they're on HOA property doing an inspection, but they're clearly harassing me. Put me on speaker so they can hear, Marcus said. His voice was sharp and professional. This is Marcus Reynolds, attorney for Robert Garrison. If you are members of the Cascade Ridge HOA board, you are violating Judge Hendrix's order. Leave Mr. Garrison's property immediately. We're on HOA property, Brenda said loudly. Then you should have no problem moving away from Mr. Garrison's property line. I suggest you do so now, or I'll be filing a motion for contempt tomorrow morning. The group exchanged glances. Brenda looked furious, but she gestured to the others and they started back to their vehicles. This isn't over, she called out as they climbed in. Actually, it is, I called back. The judge ruled, accept it. They drove off and Marcus stayed on the line. This is harassment. They're not going to let this go. What can I do? Document everything. If they come back, call the sheriff. They're trespassing and harassing you at this point, and I'm going to send another letter making it very clear that any further contact could result in a restraining order. You think it'll come to that? I think this board is used to getting their way and they're not handling the loss well. Some people double down when they're told no. Marcus sent the letter, and for a few weeks it was quiet again. I started to relax. The fee petition had been filed, and the HOA's insurance company was negotiating with Marcus about the amount. It looked like I'd recover most of my legal costs. Then the sheriff showed up at my door on a cold morning in early December. Robert Garrison, he asked. He was a stocky man in his 50s with a weathered face and a professional demeanor. That's me. What's this about? I've received a complaint from the Cascade Ridge HOA claiming you've been making threats against board members. What? That's not true. Can I come in and talk to you about it? I led him into the cabin. He looked around with the evaluating eye of someone who'd been in a lot of homes in his career, then sat down at my kitchen table. So here's what I've got, he said, pulling out a small notebook. Brenda Patterson filed a report claiming you called her on December 3rd and threatened to burn down her house if she didn't leave you alone. I never called her. I don't even have her phone number. She provided phone records showing a call from your number to her cell phone. Let me see. He showed me a printout. Sure enough, there was my phone number calling a number labeled as Brenda Patterson on December 3rd at 7:14 in the evening. I didn't make that call. You're saying someone else used your phone. I'm saying that call didn't happen. Check my phone. I pulled out my cell phone and handed it to him. Go through my call history. He took the phone and scrolled through it. No call to this number on December 3rd or any other day. Exactly. They faked those phone records. The sheriff looked thoughtful. That would be a serious accusation. They've been harassing me for months. There was a lawsuit. The judge ruled in my favor and they haven't accepted it. My attorney has all the documentation. Marcus Reynolds, you know him. I know of him. Good reputation. The sheriff handed my phone back. Look, I'm going to be honest with you. This complaint seemed off when I took it. Mrs. Patterson was very insistent that I come out here immediately and arrest you. But I've been doing this job for 26 years and I know what real threats look like. This didn't feel right. So what happens now? I'm going to note in my report that you denied making the call and your phone records don't support the claim. I'm also going to have a conversation with Mrs. Patterson about filing false reports. If she did fake those phone records, that's a crime. Thank you. Don't thank me yet. I'm not taking sides here, but I'm also not going to arrest someone based on sketchy phone records and no other evidence. He stood up. Stay out of trouble, Mr. Garrison, and keep documenting everything. If this escalates, you'll want that paper trail. After he left, I called Marcus and told him everything. He was silent for a long moment. They're really desperate, he finally said. Faking phone records to file a false police report is serious. That's a crime. The sheriff seemed to realize it was bogus. Good. But Rob, I'm worried this is going to keep escalating. These people are not rational. When you have someone who's used to power and control and you take that away, sometimes they lash out in increasingly extreme ways. What do you suggest? Get security cameras. Document your property lines clearly, and seriously consider asking for a restraining order against the board members. I installed security cameras the next day, 4 of them, covering all approaches to the cabin. They were Wi-Fi enabled and sent alerts to my phone whenever they detected motion. 2 days later, at 3 in the morning, my phone started buzzing with motion alerts. I grabbed it and pulled up the camera feeds. 3 people were walking around my cabin, shining flashlights at the windows. I called 911. There are people trespassing on my property. I have them on security camera. The dispatcher took my information and said a deputy was on the way. I watched the camera feeds. The 3 people were looking in windows, trying door handles, and one of them appeared to be spray painting something on the side of the woodshed. It took 20 minutes for the deputy to arrive, and by then the trespassers had left. But the cameras had captured everything, including clear shots of their faces. The deputy looked at the video on my phone. Can you identify any of them? That one is Donald Kemper. He's on the HOA board. I don't know the other 2. And what did they spray paint? We walked over to the woodshed with flashlights. In large red letters, someone had written, "Comply or else." The deputy took photos. This is criminal mischief and trespassing. You want to press charges? Absolutely. I'll need copies of the video footage. I sent him the files right there from my phone. He gave me a case number and said an investigator would be in touch. Marcus was furious when I called him in the morning and told him what happened. They're completely out of control. I'm filing for a restraining order today, and we need to report this to Judge Hendricks. Can we do that? She issued the order they're violating. Yes, we can report it. This is contempt of court at this point. The restraining order hearing was scheduled for the following week. In the meantime, the investigator came by to interview me and collect additional evidence. He was a younger deputy with sharp eyes and a thorough manner. I've been looking into the Cascade Ridge HOA, he said. You're not the first person to have problems with them. Really? We've had 3 other complaints in the past 2 years. Nothing criminal until now, mostly disputes about fines and access, but there's a pattern of aggressive behavior. What happens now? I'm going to interview Mr. Kemper and the other 2 individuals in the video. Based on what we've got, I think we can file charges for criminal trespassing and property damage, possibly harassment as well. What about the fake phone records? Still looking into that. Phone records can be manipulated, but it takes some technical knowledge. I've sent the records Mrs. Patterson provided to our tech unit to verify. The restraining order hearing was tense. Brenda Patterson and Donald Kemper both showed up, along with Bradford Hughes. Judge Hendricks looked at them with undisguised disapproval. "I've read Mr. Marcus's motion and reviewed the evidence, including the security camera footage. Mr. Kemper, can you explain why you were on Mr. Garrison's property at 3 in the morning?" Donald Kemper looked defiant. "We were conducting an inspection." "An inspection? At 3 in the morning? That's absurd. We have a right to ensure compliance with community standards. You have no such right. I ruled very clearly that the HOA has no jurisdiction over Mr. Garrison's property. Yet you continue to harass him. Why? We're protecting property values." "By spray painting threats on his property. That's not protecting anything. That's vandalism." Bradford Hughes stood up. "Your Honor, if I may, my clients are concerned about the precedent this case sets. Your clients should be concerned about criminal charges." "Mr. Kemper, you're facing criminal trespassing and property damage charges. You understand that? You were just breaking the law multiple times. After I issued a clear order, that's contempt of court." She turned to Marcus. "I'm granting the restraining order. All members of the Cascade Ridge HOA board are prohibited from coming within 500 feet of Mr. Garrison's property. They are prohibited from any direct or indirect contact with Mr. Garrison. And I'm finding Mr. Kemper and Mrs. Patterson in contempt of court and fining them each $1,000. If there are any further violations, I will consider jail time." Brenda Patterson's face went bright red. "This is outrageous. We're being punished for trying to maintain community standards. You're being punished for violating a court order and harassing a property owner who successfully proved you have no authority over him. If you wanted to maintain community standards, you should have stayed within your own boundaries. This hearing is over." As we left the courtroom, I saw Brenda and Donald talking intensely with Bradford Hughes. They kept glancing over at me and Marcus with expressions of pure hatred. "They're not done," I said quietly. "I know," Marcus replied. "But at this point, they're just digging themselves deeper. Let them." The criminal charges against Donald Kemper and the other 2 men from the video were filed a week later. The prosecutor's office took it seriously because of the pattern of harassment and the violation of the court order. The tech unit also confirmed that the phone records Brenda Patterson had provided to the sheriff were fabricated. Someone had created a fake document that looked like legitimate phone company records, but contained a call that never actually happened. That resulted in charges against Brenda for filing a false police report and forgery. The local newspaper picked up the story. "HOA board members charged in harassment case," read the headline. The article detailed the whole saga, from the initial violation notice to the spray painting incident to the fake phone records. Suddenly, I was getting calls from other property owners who'd had problems with Cascade Ridge and other HOAs. One call was from a woman named Grace Bennett who lived about 2 miles from me. "I'm dealing with almost the same thing," she said. "The HOA is claiming my property is in their boundaries even though I was here first. Can I get your attorney's number?" I gave her Marcus's information and told her about the Silverton case he'd cited. "There's precedent for this. You've got a good chance of winning." "Thank you. I've been so stressed about this. They've been threatening to fine me $10,000. Don't pay them anything. Get a lawyer and fight it." Over the next few weeks, I heard from 4 other people with similar stories. The Cascade Ridge HOA had apparently been trying to expand their jurisdiction by claiming boundary overlaps with neighboring properties, hoping people would just comply rather than fight. Marcus filed a class action lawsuit on behalf of all the affected property owners. The lawsuit alleged that the HOA had engaged in a systematic pattern of harassment and fraudulent boundary claims to expand their authority and collect fines. The criminal cases went to trial in March. I had to testify about the harassment, the violation notices, and the trespassing incident. The security camera footage was played in court, clearly showing Donald Kemper and the other two men spray painting my woodshed. Donald's attorney tried to argue that he was just conducting HOA business, but the prosecutor demolished that argument. At 3 in the morning, spray painting threats. That's not HOA business. That's criminal behavior. The jury convicted all 3 men of criminal trespassing and property damage. Donald got 90 days in jail and probation. The other 2 got probation and community service. Brenda Patterson's trial was separate because her charges were different. The evidence of the fake phone records was damning. The prosecutor showed how the document she'd provided to the sheriff had formatting inconsistencies and impossible metadata that proved it was fabricated. Mrs. Patterson didn't just file a false report, the prosecutor said in closing arguments. She created false evidence to support that false report. That's forgery. That's serious. And she did it to try to get an innocent man arrested because she was angry about losing a lawsuit. That's not acceptable behavior from anyone, let alone an HOA board president. Brenda was convicted of filing a false police report and forgery. The judge gave her 6 months in jail and 2 years probation. The class action lawsuit settled in April. The Cascade Ridge HOA's insurance company agreed to pay damages to all affected property owners, issue a formal apology, and redraw their boundary maps to exclude any properties that predated the HOA. The total settlement was $250,000, split among 7 property owners. I got $40,000, plus Marcus's fees were covered. More importantly, the HOA was required to send a letter to all properties within 5 miles explicitly stating that pre-existing properties were not subject to HOA jurisdiction and apologizing for any harassment. I was sitting on my porch reading that letter when Grace Bennett drove up. We'd become friends during the lawsuit process. "Can you believe it?" she said, holding up her own copy of the letter. "They actually apologized, only because they were forced to. Still, I'll take it." She sat down on the porch steps. "You know, when this all started, I was terrified. I thought I might lose my property. Me too. Thank you for fighting this. If you'd just given in, the rest of us probably would have too. I couldn't let them bully me. This cabin means too much to me. My grandfather built it with his own hands. I get that. My place has been in my family since the 50s too. These HOAs think they can just steamroll over history." We sat in comfortable silence for a moment, looking out at the mountains. "What happened to the HOA board?" Grace asked. "I heard they all resigned." "They did. After the criminal convictions and the lawsuit, the HOA members voted them all out. There's a new board now. Think they'll be any better? Hard to say. But at least the boundaries are fixed now. They can't try this again." Grace left after a while and I stayed on the porch, watching the sun set. The cabin looked the same as it always had, weathered gray logs and a metal roof that had been here for decades. No architectural shingles, no decorative shutters, no landscape lighting. Just a simple cabin in the woods, exactly like my grandfather had built it. My phone rang. It was Marcus. "Hey, I wanted to let you know the final settlement check cleared. You should see the money in your account tomorrow." "Thanks for everything, Marcus. I couldn't have done this without you. You did the hard part. You stood your ground when a lot of people would have just given in. That takes courage. After we hung up, I thought about that. Had it taken courage or just stubbornness? Maybe both. All I knew was that I wasn't going to let anyone take this place away from me or force me to change it into something it wasn't. The next morning, I was having coffee when I heard a vehicle coming up the road. I tensed for a moment, then relaxed when I saw it was just the mail truck. The mail carrier waved as she dropped off a small package and some letters. One of the letters was from the county assessor's office. I opened it expecting a tax bill, but instead found something else. It was a notice that a formal boundary survey had been completed for the Cascade Ridge HOA area, confirming that my property was entirely outside the HOA boundaries with no overlap. The letter stated that this survey had been filed with the county and was now the official record. I smiled. It was finally, truly over. Over the following months, life returned to normal. I worked on my design projects, hiked the mountains, and enjoyed the peace of living in a place that had been in my family for 7 decades. No violation notices appeared on my door. No one showed up to tell me I needed to paint or install shutters. The HOA left me alone. In June, I got a call from a reporter at a Denver newspaper. "Mr. Garrison, I'm writing a story about HOA overreach. Would you be willing to talk about your experience?" I agreed and spent an hour on the phone describing everything that had happened. The story ran a week later with the headline, "When HOAs Go Too Far: How One Colorado Man Fought Back Against Harassment and Won." The article generated a lot of discussion. I got emails from people across the country who dealt with similar issues. Some had won their battles. Others were still fighting. A few state legislators even reached out asking if I'd be willing to testify in support of HOA reform legislation. I thought about it and decided to do it. In August, I drove down to the state capitol and testified before a committee considering a bill that would limit HOA authority over pre-existing properties and increase penalties for HOA harassment. "What happened to me shouldn't happen to anyone," I told the committee. HOAs serve a purpose in maintaining property values in planned communities. But when they overstep their bounds and try to force people into compliance through harassment and intimidation, that's not acceptable. We need clear laws that define HOA authority and provide remedies when they abuse that authority. The bill passed in October and was signed into law by the governor in November. It wasn't perfect, but it would make it harder for HOAs to pull what Cascade Ridge had tried with me. On a cold December morning, almost exactly a year after the spray painting incident, I was sitting on my porch when Grace Bennett drove up again. "I brought something for you," she said, getting out of her car with a wrapped package. "You didn't have to do that." "I wanted to. Open it." I unwrapped a framed photograph. It showed my cabin from the road, the weathered logs and metal roof stark against a backdrop of snow-covered mountains. It was a beautiful shot. "I took it last winter," Grace said. "I thought you might want it, a reminder of what you fought for. It's perfect." Thank you, for standing up to them, for fighting when it would have been easier to just give in. You saved my property too, you know. If they'd succeeded with you, they would have come after all of us. After she left, I hung the photograph inside the cabin, right next to the framed original deed from 1952. 2 pieces of history, one old and one new, both telling the story of this place and my family's connection to it. I thought about my grandfather, building this cabin by hand back when this whole area was undeveloped wilderness. He'd probably never imagined that someday an HOA would try to claim authority over his property. But he'd built something solid and lasting, and I'd been able to protect it. That evening I called my sister in Phoenix. She'd inherited some money from Dad too, but had chosen to sell her share of the property to me when I'd offered to buy her out. "Hey, just wanted to let you know everything's finally settled with that HOA mess," I told her. "Thank God. I was worried they were going to tie you up in legal battles forever. They tried, but we won. The cabin's safe. Good. I'm glad you kept it. I know how much it meant to Dad and to Grandpa before him. It means a lot to me too. Are you going to stay up there long term? I think so. I like it here. It's peaceful. Well, when the HOA isn't harassing me, she laughed. At least that's over now. We talked for a while longer, catching up on family news. After we hung up, I walked outside. It was a clear night and the stars were brilliant in the unpolluted mountain air. The cabin sat solid and quiet behind me, exactly as it should be. I stood there for a long time, breathing in the cold air and feeling grateful. Grateful that I'd stood my ground. Grateful for Marcus's legal help. Grateful that the system had worked eventually and that justice had prevailed. Most of all, I was grateful for this place. For the cabin my grandfather had built, for the land that had been in our family for generations, and for the peace and solitude I'd found here after my life had fallen apart. The HOA had tried to take that away from me. They tried to force me to change everything to fit their vision of what the property should look like. But they'd failed. The cabin still stood, weathered and rustic and perfect, exactly the way it had been built 70 years ago. And it would stand for 70 more, long after the Cascade Ridge HOA was forgotten. I went back inside, added another log to the fire, and settled in for the night. Tomorrow, I'd wake up and make coffee and work on whatever design project needed attention. I'd hike if the weather was good, or read by the fire if it wasn't. I'd live my life the way I wanted on my own property, answering to no one. That's what freedom looked like. That's what my grandfather had built this cabin for, and that's what I'd fought to preserve. The HOA had tried to annex my cabin, not knowing that my deed predated their entire charter by 4 decades. They'd learned the hard way that some things can't be changed, some rights can't be violated, and some people won't back down no matter how much pressure you apply. I was one of those people, and my cabin, my family's cabin, would remain exactly what it had always been: a refuge, a sanctuary, and a piece of history that no HOA could ever touch.